welcome to this explainer. Look, we hear about this separation of powers in the abstract all the time, right? But today, we're diving straight into what happens when two branches of government literally collide over who gets to run the law enforcement machinery of the United States. We're looking at a shocking, real-world event out of Seattle that perfectly illustrates a massive constitutional crisis that's brewing right now. So, let's jump right in. Can a president fire a federal prosecutor in under an hour? I mean, it sounds like a ridiculous law school hypothetical, doesn't it? But on July 15, 2026, it actually happened. Roger Rogoff, a veteran state and federal prosecutor and a former judge, was unanimously appointed as Seattle's top U.S. attorney by a panel of federal judges. But as you're about to see, his tenure lasted less than 60 minutes. Literally. The timeline of that morning is just wild. It was a completely dizzying pace. Rogoff was officially sworn in before 8 a.m. By 8:30, he heads over to his new office, standing in the lobby, getting ready to meet his staff. And then at exactly 8:40 a.m., he gets an email from the Trump administration. The message? He's summarily fired. Before the guy could even sit at his new desk, his time as the top federal cop in Western Washington was completely over. So what we have here is a direct head-on collision of power. On one side, federal judges used a statutory safety valve, basically a legal mechanism that lets them fill a U.S. attorney vacancy if the Senate leaves it open for too long. And this specific seat, it had been sitting empty for 3 whole years. On the other side, the Trump administration stepped in and asserted its absolute right to remove Rogoff instantly, choosing to keep their preferred pick, Charles Neal Floyd, in charge as first assistant. And that's despite the fact that Floyd was never actually confirmed by the Senate. As you can imagine, the political fallout was explosive. Democratic Senator Patty Murray came out swinging, strongly condemning the immediate firing. Her argument was that the administration was deliberately sidestepping the Senate's constitutional advice and consent process, essentially just to install a political ally who would, in her words, act as a sock puppet and put the president above the rule of law. But the administration totally stood its ground. Acting Attorney General Todd Blanche fired back, saying that it was actually the district court judges who abandoned the long-standing process of consulting with the administration. From their perspective, the legal math was super straightforward. Sure, judges have the power to appoint a temporary U.S. attorney, but the president holds the ultimate constitutional authority to fire them. Period. Okay, so that brings us to the underlying legal foundation of this whole mess, the Unitary Executive Theory. So what exactly is this theory? Basically, it argues that because the Constitution vests executive power exclusively in the president has to have absolute, unbridled control over the entire executive branch. The idea is that to faithfully execute the laws, a president needs the power to supervise, direct, and, crucially, summarily fire absolutely any subordinate who is executing the law. Under this view, there's no scenario where Congress or the courts can shield an executive officer from the president's chopping block. But here's where the legal friction actually lives. Article 2 of the Constitution vests executive power in the president, sure, but it doesn't actually explicitly mention presidential removal powers anywhere. Instead, we get this massive constitutional tug-of-war with Article 1, which grants Congress the necessary and proper clause. That's the clause giving Congress the power to create and structure government departments. So the million-dollar question is, does Congress's power to structure these departments include the power to limit who the president can actually fire? Let's move on to this constitutional tug-of-war and look at what the framers actually intended. You know, for the first century of the United States, there was actually a pretty solid consensus on this balance. The decision of 1789 established early on that the president could fire top cabinet officers at will. But, and this is a big but, even George Washington approved statutes that gave fixed terms to specific expert commissions. By 1887, Congress created the Interstate Commerce Commission with strict for-cause removal protections. The general understanding back then was that Congress absolutely could legally protect non-cabinet experts from being summarily fired by the president. Which leads us into decades of legal battles and some major shifts at the Supreme Court. As the federal government ballooned during the 20th century into the massive administrative state we have today, the Supreme Court's stance on this firing power began to aggressively ping-pong back and forth. The legal whiplash is honestly striking. In 1926, in a case called Myers, the court gave the president incredibly broad removal powers. But wait, just under a decade later, in 1935 with Humphrey's executor, and the court completely reverses course to protect independent agencies from being fired over policy disagreements. Fast forward to 2020 with the Selah Law case, and the court swings right back toward empowering the president, striking down removal protections for the head of the Consumer Financial Protection Bureau. Talk about a roller coaster. So, you might be wondering, why the recent swing back to presidential power? Well, the modern resurgence of this unitary executive theory really kicked off during the Reagan administration in the 1980s. Justice Department officials and legal scholars dug it up and refined it, arguing forcefully that a unified, hierarchical executive branch is exactly what the Constitution demands. And that intellectual movement, it has fundamentally reshaped how a majority of today's Supreme Court justices view presidential authority. Today, this is the absolute core of the academic fight. Legal scholars are fiercely debating a very specific distinction. Is an absolute removal power indispensably necessary for the president to function, or is it just a beneficial power that Congress has the right to put limits on? Because if it's only beneficial, then Congress can set rules, like requiring good cause before firing a commissioner, or, you guessed it, allowing local judges to appoint a federal prosecutor. Let's bring this all back to the present day and look at the current legal showdowns testing this executive power. The rapid-fire dismissal of Roger Rogoff in Seattle perfectly mirrors a massive upcoming Supreme Court case called Trump v. Slaughter. Over in Washington, D.C., the president aggressively applied this exact unitary executive theory by firing FTC Commissioner Rebecca Slaughter before her fixed statutory term expired and, importantly, without the statutory good cause. Both the 60-minute drama in Seattle and this high-profile D.C. firing are testing the exact same limits of executive power. The stakes in the Slaughter case are just astronomical. The Supreme Court is going to decide whether to extend the unitary executive theory to multi-member independent agencies. I mean, they could outright overrule that 90-year-old precedent from Humphrey's executor we talked about earlier. Ultimately, this decision is going to determine if Congress can ever, and I mean ever, require good cause for firing executive branch officials, or if the president truly has an absolute, unchecked power to fire anyone they want. Which leaves us with a profound final question to ponder as we watch this all play out in Seattle and at the highest court in the land. When the executive branch and the judicial branch clash over the exact same constitutional authority to run the government, when judges appoint a prosecutor and the president fires him 60 minutes later, who ultimately wins? The answer is going to completely redefine the balance of American government. Thanks so much for joining me for this explainer.